Hello future travelers, welcome back to Legalopolis. In our previous videos, we have thoroughly covered the crucial steps for visa application and interview preparation for B1 and B2 visas. You can find their links in the description box for easy reference. Now friends, even though the US Embassy approves a good number of visa applications, visa denials are also quite common, and there are various grounds on which a visa application may be denied. And therefore, it is equally important for an applicant to understand the reasons because of which a visa application can be denied. This will help the applicant, that is, all of us, to avoid potential pitfalls and strengthen our application so that we can easily avoid these denials. In this video, let's get straight into the reasons for visa denials. Now friends, US visa officers operate under the guidelines stated in the Immigration and Nationality Act of the US Code, particularly Section 104A, because it is this section which grants these consular officers the exclusive authority to approve or deny a visa. Now, the most common form of ineligibilities which become the ground for visa denial are ineligibility under Section 214B of the Immigration and Nationality Act. A visa denial under Section 214B for non-immigrant visas has two potential meanings. Number 1, not meeting visa category requirements. This means you couldn't prove to the consular officer that you meet the specific requirements for a particular non-immigrant visa category that you applied for. For instance, if you applied for a B1, that is business visitor visa, and couldn't present compelling evidence of a business purpose, or if you couldn't establish a clear purpose for your visit under the B2 visa category, your application may be denied under Section 214B. I've created a comprehensive video on the application process for B1 and B2 visas, including the required supporting documents to substantiate your business or tourism intent. The link is in the description box, and I would highly encourage you to take a look at it. And the second one, failing to overcome presumption of immigrant intent. What it means is, under the immigration law in United States, the visa officer is required to presume that every applicant, that includes even those applicants who are applying for non-immigrant visas, have an immigrant intent, unless the applicant can prove otherwise to the consular officer during visa interview. Therefore, in these cases, the burden of proof is with the visa applicant to convince the visa officer that they intend to return to their home country after their authorized stay in the United States. Failure to prove this intent to return to your home country can result in a denial of visa under Section 214B. This evaluation is done by the consular officer during the interview, thereby further emphasizing the importance of adequate preparation to avoid denials, because any denial under 214B means that you will have to reapply for a visa and start the entire application process from the beginning. To address this aspect, applicants must present evidence by demonstrating strong ties to your home country. Now, in this context, strong ties refers to those aspects of your life that bind you to your home country and would compel you to return to your home country after a temporary stay in the United States, such as residence, employment, school enrollment, social relationships, family, etc. So friends, in order to show proof of strong financial ties to your home country, you can show ownership of property, like proof of residence. So for that, you can carry a copy of the official registration documents showing home or land ownership, or copy of utility bills like electricity bill to show that you live here. Or you could show proof of investments or maintaining bank accounts in the home country by carrying bank statements. In order to show strong employment ties, if you are employed, Demonstrate that you have a stable job in your home country by carrying your employment letter or salary slip, certified tax returns, and bank statements. If you are self-employed in your home country, certified copies of tax records related to the business, bank account details can serve as official documentation of your financial activities and proof of possession of property from where you run your business, for example, lease agreements, which can confirm your business location, will further add credibility to your claim. Additionally, in some cases, providing photos of the business premises can further support your claim. If you are currently enrolled in a school or university in your home country, please carry evidences such as a letter from the school principal or university dean, along with recent mark sheets showing enrollment in a school program. This documentation serves as proof of your academic commitments and reinforces your ties to your home country. In order to highlight close family ties, you must show close family members like parents, spouse, children, siblings residing in the home country. You can prove this by bringing relevant birth certificates, marriage certificates where your name is mentioned along with your child, parent, spouse, etc. to show close family connections. If possible, carry some family photos to show the visa officer if needed. Another way to convince the visa officer of your intent to return to your home country is by establishing a positive travel history. So, for example, if you have previously traveled to the US or any other country, please take along your previous passports that demonstrate that you always adhered to the terms of the visa and did never overstay beyond the visa duration during your past visits to any of the countries where you have visited. This will help add credibility to your application. Friends, here it is important to mention that H-1B and L visa applicants, along with their immediate family members, are exempted from proving strong ties to their home country under Section 214B. This is because these H-1B and L visas are specifically for temporary skilled workers or for intra-company transferees who have established ties to their employers. Now friends, the good thing about visa denial under Section 214B is that it is not permanent, meaning that if your visa is denied by the visa officer, you can start the reapplication process, and during the next interview, make sure to carry the proofs that we just discussed to support your case, and I'm sure your visa will not be denied on these grounds again. Now friends, another common ground for visa denial happens under Section 221G of the Immigration Act. A visa refusal under Section 221G signifies that the applicant failed to establish eligibility for the visa to the satisfaction of the consular officer as is required by the immigration law. Now what this means is that something in your application or your background has raised red flags or concerns about your eligibility. Now here, there can be two outcomes. The visa officer can either deny your visa or put your visa application on hold on grounds of needing further review. Now friends, there are three main reasons for denial of visa under this section. Number 1, incomplete application or documentation. Number 2, administrative processing. And number 3, the applicant is ineligible under Section 212 of the Immigration Act. If your application or supporting documents are incomplete, you will be informed of these deficiencies. A letter will specify the missing documents and you can provide them to the embassy or consulate. You will be informed of all this at the end of your interview. Once the required documents are submitted, your visa application will be re-evaluated. In this case, make sure to promptly provide the missing documents as soon as you receive the refusal letter. You will generally have 1 year from the refusal date to submit the required documents and information. However, if you fail to submit the necessary information within 1 year for an incomplete application, then you must reapply for the visa and pay a new application fee. Therefore, it is important to keep track of the specified timelines and follow the instructions provided in the refusal letter, and make sure that you submit the documents that have been asked for as soon as possible. The second reason is administrative processing. What it means is that if the consular officer couldn't determine your eligibility during the interview and feels that additional administrative processing is necessary to decide your case, then your visa will be denied. You will be informed about this also at the end of the interview, and you will receive a letter indicating the same. Once the processing is complete, the embassy or consulate will contact you. Normally, administrative processing takes additional time and the durations vary based on individual cases. So please be patient. Now, this section, that is 221G, also empowers the consular officer to deny a visa if the visa officer knows or has reason to believe that the applicant is ineligible under Section 212 of the Nationality Act. Now, Section 212A of the Immigration and Nationality Act, it is an extensive legal provision. It outlines various grounds of inadmissibility for applicants seeking entry into the United States. It applies to both immigrants and non-immigrants. Section 212 plays a crucial role in controlling who can enter the United States and is aimed at protecting the national security, public health, and safety. Most of the denials under this category are for serious violations like criminal convictions, money laundering, or committing criminal offenses in the United States, being involved in human trafficking offenses, drug abuse or addiction, engaging in activities related to espionage, sabotage, and unlawful activity, those people whose entry could have serious and adverse foreign policy consequences for United States, involvement in terrorism or related activities, etc. Another serious reason is when the applicant attempts to receive a visa or enter the United States by willfully misrepresenting a material fact or committing fraud. This means that the applicant deliberately and falsely misrepresented facts, which, if would have been known to the visa officer, would have resulted in a visa denial. Then in these cases, the applicant may be permanently ineligible for a visa. Permanent ineligibility means that every time a visa applicant will apply for a visa, it will be denied by the visa officer under the same section of law and for the same reasons. The only way an applicant can get a visa in these situations is by requesting a waiver, which can only be issued or authorized by the Department of Homeland Security in the US. The Immigration and Nationality Act contains provisions that may allow a visa applicant who was denied a visa for a particular ineligibility to apply for a waiver of that ineligibility. The consular officer at the US Embassy or consulate where you applied will advise you if you may apply for a waiver of your ineligibility. All waivers of ineligibility are decided by the Department of Homeland Security. These waivers are discretionary, meaning there are no guarantees that DHS will approve a waiver for you. However, if the waiver is approved, you may be issued a visa by the embassy. So friends, in summary, visa denials can occur for various reasons, and it is crucial to understand the specific requirements of the visa category you are applying for. Each visa category has certain unique criteria, and applicants should tailor their approach accordingly. It is essential to provide documentary proof of demonstrating your intent to adhere to visa terms, such as the duration of stay, and establish strong ties to your home country, especially for non-immigrant visas like B1, B2, or student visas. Prepare thoroughly for the visa interview. Ensure consistency between your DS-160 application and your interview responses. Carry documentation supporting the purpose of your visit. While facing a denial can be disheartening, it's an opportunity for you to reevaluate your application address shortcomings, and follow advice for future attempts. For additional tips, you can always refer to the video on interview preparation. With these insights, you are well equipped to navigate your visa preparation and visa denials confidently. Best of luck on your journey, and may your visa application be met with success. If you found this guide helpful, please don't forget to like, share, and subscribe for more valuable tips. Safe travels!